All right, we don't want to cut corners when it comes to foundational estate planning documents, and one of those is the power of attorney. Such an important document, and we don't want to have problems when we go and use the document as far as it not being prepared properly or having the wrong situation set up. So first of all, I do want you to think this through as far as the people in your life who could act on your behalf, whether you just want them to or there's a critical need. Who's the person who could be most appropriate, act in your best interest in those times? And then you're going to think about whether it's going to be one person or two people who may be able to act as your primary agent or agents. Now you can also have successor agents, and same thing, you're going to think about one person or two people who could act in your best interest because either you just want them to or it's a critical need and you need them to. And you're going to talk to your estate planning attorney about those proper arrangements. And in each situation, primary agent, successor agent, if you're going to allow them to act separately or they must act together, there's a whole host of things to think about there. Now remember, a power of attorney is foundational. We want to have this in place before there is a need, because if there is a need and we don't have this document in place, we are going to have to go to Supreme Court for an adult guardianship proceeding, because there is nobody who has legal authority to handle financial matters on your behalf. I've seen loved ones go through a horrible time as far as this document not being at the ready or not being even accepted because it wasn't properly prepared in a time of need, and then have to go through the guardianship proceeding, which is very costly, time consuming, and just not fun for people to have to go through. That's when you would have a Supreme Court judge determine all the facts and circumstances, determine if the person who needs a guardian potentially is indeed incapacitated, and if so, who would be the appropriate guardian and what powers do they need. It's a lengthy proceeding. Again, it costs time, money, a lot of energy. Now, if you have a power of attorney in place, but it wasn't properly prepared or executed, or perhaps the agent is doing the wrong thing, then we could still need an adult guardianship proceeding, because now we have somebody who's concerned that the agent is not acting appropriately. They could still seek an adult guardianship proceeding in Supreme Court to void the power of attorney and have everything now under this guardianship where there'll be court involvement year after year. And so I really want people not to cut corners in setting up this document. I want people to be properly counseled, have some education about what it means, have the people in their life understand what it means, and have it properly prepared, properly executed. We do not want to have a problem because of those things not being done right from the get-go, from the beginning. So be proactive, have this very critical, important estate planning document done properly, and be ready in a time of need. This is Ruth George with Ruth P. George Law, PLLC, Trust and Estate Attorney. This video, as with any video I do put out, is for educational purposes only. It does not establish an attorney-client relationship, and I look forward to seeing you on another video.